A shareholders agreement, SHA in short, is an agreement amongst the shareholders of a company. In strict legal theory, the relationships amongst the shareholders and those between the shareholders and the company are regulated by the constitutional documents of the company. However, where there are a relatively small number of shareholders, like in a startup company, it is quite common in practice for the shareholders to supplement the constitutional document. There are a number of reasons why the shareholders may wish to supplement the constitutional documents of the company in this way. A company's constitutional documents are normally available for public inspection, whereas the terms of a shareholders agreement, as a private law contract, are normally confidential between the parties. Contractual arrangements are generally cheaper and less formal to form, administer, revise or terminate. The shareholders might wish to provide for disputes to be resolved by arbitration, or in the courts of a foreign country. In some countries, corporate law does not permit such dispute resolution clauses to be included in the constitutional documents. Greater flexibility. The shareholders may anticipate that the company's business requires regular changes to their arrangements, and it may be unwieldy to repeatedly amend the corporate constitution. Corporate law in the relevant country may not provide sufficient protection for minority shareholders, who may seek to better protect their position by using a shareholders agreement, to provide mechanisms for removing minority shareholders which preserve the company as a going concern. Risks. There are also certain risks which can be associated with putting a shareholders agreement in place in some countries. In some countries, using a shareholders agreement can constitute a partnership, which can have unintended tax consequences, or result in liability attaching to shareholders in the event of a bankruptcy. Where the shareholders agreement is inconsistent with the constitutional documents, the efficacy of the parties' intended arrangement can be undermined. Countries with notarial formalities, where notarial fees are set by the value of the subject matter, parties can find that their agreement is subject to prohibitively high notarial costs, which, if they fail to pay, would result in the agreement being unenforceable. In certain circumstances, a shareholders agreement can be put forward as evidence of a conspiracy and/or monopolistic practices. Common characteristics. Shareholders agreements obviously vary enormously between different countries and different commercial fields. However, in a characteristic joint venture or business startup, a shareholders agreement would normally be expected to regulate the following matters: regulating the ownership and voting rights of the shares in the company, including lockdown provisions, restrictions on transferring shares, or granting security interests over shares, preemption rights and rights of first refusal in relation to any shares issued by the company, tag-along, and drag-along rights, minority protection provisions. Control and management of the company, which may include power for certain shareholders to designate individual for election to the board of directors, imposing supermajority voting requirements for reserved matters, which are of key importance to the parties, imposing requirements to provide shareholders with accounts or other information that they might not otherwise be entitled to by law. Making provision for the resolution of any future disputes between shareholders, including deadlock provisions, dispute resolution provisions. Protecting the competitive interests of the company, which may include restrictions on a shareholder's ability to be involved in a competing business to the company, restrictions on a shareholder's ability to poach key employees of the company, key terms with suppliers or customers who are also shareholders. In addition, shareholders' agreements will often make provision for the following: the nature and amount of initial contribution to the company, the proposed nature of the business, how any future capital contributions or financing arrangements are to be made, the governing law of the shareholders' agreement, ethical practices or environmental practices, allocation of key roles or responsibilities. Registration. In most countries, registration of a shareholders' agreement is not required for it to be effective. Indeed, it is the perceived greater flexibility of contract law over corporate law that provides much of the raison d'etre for shareholders' agreements. This flexibility, however, can give rise to conflicts between a shareholders' agreement and the constitutional documents of a company. Although laws differ across countries, in general most conflicts are resolved as follows: as against outside parties, only the constitutional documents regulate the company's powers and proceedings. As between the company and its shareholders, a breach of the shareholders' agreement which does not breach the constitutional documents will still be a valid corporate act, but it may sound in damages against the party who breaches the agreement. As between the company and its shareholders, a breach of the constitutional documents which does not breach the shareholders' agreement will nonetheless usually be an invalid corporate act. Characteristically, courts will not grant an injunction or award specific performance in relation to a shareholders' agreement where to do so would be inconsistent with the company's constitutional documents. Footnotes. External links: Shareholders Agreement Guide, English and Welsh Law.